Richard Lloyd, in the 1680s, seems to have been the first dean of arches to have been called to the bar at Gray's Inn in 1655, doubtless with an eye to the imminent demise of the college in the 1850s. 19th century deans belonged to Doctors' Commons and to an Inn of Court, like John Dodson, Middle, and the great Stephen Lushington, Inner. But James Wilde, Lord Penzance, called at Inner in 1839, was the first non-civilian dean appointed, and that was 1875. The lawyers. By the late 13th century, advocates and proctors, equivalent roughly to barristers and solicitors today, had become a regulated body of professional lawyers, mostly law graduates. The 1281 Statutes of the Arches Court required 3 years' study of civil and canon law, the 1295 Statutes 4 years, and those of 1342 the degree of Bachelor of Canon and Civil Law. There was, however, a practice that advocates had to have a doctorate in civil or canon law. Now, under Henry VIII, the canon law faculties at Oxford and Cambridge were dissolved, but the civil law faculties continued, and so did the practice of requiring an advocate to be a doctor of civil law, itself formalised in Doctors' Commons Royal Charter of 1768. There were also norms on professional ethics and numbers. The 1295 Statutes forbade advocates and proctors to enter taverns, to keep concubines, to wander at night, and to attend public entertainments. They allowed 16 advocates, 10 proctors. By the 1530s, the statutes allowed 21 proctors, and by 1583, 28. And in 1746, there were 23 advocates and 34 proctors. The vast majority were not members of an Inn of Court. Now, George Squibb, treasurer of Inner Temple, 1976, wrote The History of Doctors' Commons in 1973. From its register, he lists, and sadly, I've gone through the lot, he lists 1,000 advocates admitted from 1505 to 1855, when its last advocate was enrolled. In the 16th century, only 2 advocates also belonged to an inn, one probably Lincoln's and the other Inner. From 1600 to 1855, those who had been or became a student and or called at an inn were roughly 11 Grays, 14 Middle, 13 Inner, and 10 Lincolns. With abolition in 1857 of church court jurisdiction over marriage and wills and the resultant demise of Doctors' Commons, the advocates and proctors withered. The inns won, effectively. Barristers replaced the advocates and solicitors replaced the proctors. 3 records of the court. The records of the Arches Court were in Latin till Parliament forbade its use in 1733. Today, the Arches records are mostly at Lambeth Palace Library. There are over 2,000 process books of cases going to the Arches, over 150 volumes of act books, depositions and sentences, and over 1,000 19th century case files. The records were previously stored in various places, from 1674 at Doctors' Commons. After 1857, they were stored in a well in St. Paul's Churchyard, and in 1865 at Morton's Tower at Lambeth Palace. In World War II, the records were held at the Bodleian, and in 1953 deposited at Lambeth Palace Library, where they remain. 4, procedure and practice of the Arches. Now, medieval court procedure was complex. For the Arches Court, the procedure was set out in the Archbishop's statutes and in what came to be known as precedent books. And Inner Temple has a real treasure. Manuscript 511-3. And we're very grateful to Rob Hodgson, Inner Temple librarian. The manuscript is here somewhere I understand, which is wonderful, so we can take a peep at that later. The note attached to the manuscript describes it as a formulary of ecclesiastical courts containing treatises on processes in the Court of Arches. Conway Davis, who incidentally is from Llanelli, editor of the 1972 Catalogue of Inner Temple Manuscripts, writes that it is probably the earliest surviving precedent book of ecclesiastical courts. It contains documents from 1278 to 1323. The precedents relate, for example, to citations, sentences, to appeals. Now, as Conway Davis points out, many of these procedures would, of course, be applicable to any ecclesiastical court, but some apply only to the Court of Arches or the Court of Audience of Canterbury, that is. As such, they should therefore be regarded as primarily a precedent book for these two courts. Now, Donald Logan, too, in his book, The Medieval Court of Arches, 2005, includes one extract from folio 178 of the Inner Temple manuscript, with examples of forms used in the Arches Court for appeals, and we still await a study of this extraordinary manuscript. After the Reformation, the medieval procedure and practice continued largely unchanged. As Orton writes in 1728, when in the seat of justice, the dean was addressed as Domine Judex or Domine Decane, and when spoken of as Mr. Dean with great deference. All documents style the dean as venerable, mark this, Robin, and excellent, because the dean was on an equal footing with the Archbishop. Next, the admission of advocates. Philip Floyer explains in 1746, on petition to the Archbishop and his fiat obtained, they are admitted by the judge on condition that they practice not for 1 whole year after admission, called the silent year. 2 senior advocates with the mace carried before them conduct them up to the court with 3 low bows and present them with a Latin speech and produce a rescript from the Archbishop. After taking the oaths, the judge admits them and assigns them seats in court on his right or left hand, and proctors were admitted similarly but practiced immediately. Floyer also describes dress. Judge and advocates wear scarlet robes and hoods lined with taffety, if bred at Oxford, or white miniver, if at Cambridge, and round black velvet caps. Proctors wear black prunella gowns with hoods lined with fur, in this court only, the Arches. In other courts, the doctors wear only black. Now, the practice and procedure of the Arches Court changed dramatically in the later 19th century. Canons of 1874, created by the Convocations, required the dean to frame orders to regulate the practice and process of all the courts in the province. By 1895, Philibor has a table of procedure rules for the Arches and other courts on, for example, general procedure, 1867, clergy discipline cases, 1892, scales of fees and costs, 1893, and faculty rules of 1867 were updated in 1903 and lasted until 1936. 5, we're almost there now, the jurisprudence of the court. The Arches Court judges, advocates, and proctors gave much to ecclesiastical law. First, their commentaries and opinions. Of the medieval deans, William Lindwood, Bishop of St. David's, is the best known. His Provinciale of 1436 discusses domestic English church law and is still cited today. After the Reformation, the temporal court often called on the advocates to assist in a case. Grendon's case, 1575, in Common Pleas, was typical. 6 civilians, doctors of the arches, all named, that a proposition was good in law. The practice continued in the 17th century. And for this study, I've used works by Arch's staff, from Proctor Floyer and his 1746 book to Dean Phillimore and his monumental Ecclesiastical Law, 1873. Second, there is the practice of writing up Arch's decisions. A Bodleian manuscript has late Elizabethan Arch's decisions. Sir George Lee collected his judgments as Dean in the 1750s, published in 1855. And reporting Arch's judgments went up a gear, rather strangely, in the 19th century, such as those by Jesse Adams, John Haggard, and Thomas Spinks, all republished in the English reports. Third, so many landmark Arch's decisions have developed the ecclesiastical law of England. Some examples. 1628, the Arches hold that a judge cannot compel an executor to produce an inventory and render an account before a will has been proved. 1753, church courts must apply common law rules to determine whether an ecclesiastical custom exists. 1758, parishioners have a right to be married in the parish church. 1809, lay persons can administer the sacrament of baptism. In 1830, the incumbent is custodian of the keys of the church. It's very, very, very important, that. 1876, punishing the laity for the good of their souls would not, said the Arches Court, be in harmony with modern ideas. And in 1908, the Arches Court held that parties lawfully married in the civil law cannot be denied Holy Communion, even if the Church's teaching forbids their marriage. So, needless to say, I give a very, very incomplete history of the Court of Arches. Sir George Lee in the 1750s may well have been correct that its jurisdiction was entirely settled before then. But even by the 1750s, the court had already undergone great changes in its jurisdiction, its personnel, its processes, and so on. And so it continued into the early 20th century. The history of the court is clearly one of evolution, continuity and change, driven by principle, politics, and pragmatism. So, there's no better way to end this part of the talks this evening than with Thomas Orton's words in 1728, written 20 or so years before George Lee was dean. Orton says, "Long may this useful, this illustrious, this splendid court, the Arches Court of His Grace of Canterbury, continue to shine effulgent, and may its glory extend far and wide to distant ages." My question is, did it? Thank you very much.
Thank you very much, Norman. What a warm-up act. Well, you've talked about the jurisprudence of the court being allegedly settled, and for those of us who've ever done any advocacy, it's always a little unsettling to appear in an unfamiliar court. But this short talk now is designed, if you like, as a settling guide to the contemporary court, for it does still exist. The slides that we'll be seeing will be available online afterwards for anybody who suddenly finds themselves unexpectedly due to appear in the court. And I'm told that the students in the Inner Temple Ecclesiastical Law moot will also be made to read them because they might find them useful. And this is a little advertisement for the final of the moot, which will be held, as always, in the Temple Church in May, so do come along to that if you would like to. This talk will therefore deal mostly with procedure rather than substantive law, and if I tried to do that as well, I think we'd be here all night. The modern courts and their jurisdiction, and those I hope you can all manage just about to see the slides. You'll see there a picture of England and the Isle of Man, and the top bit in pink is the Northern Province, ruled over by the Archbishop of York, and the golden bit in the south, the bigger bit, is the province of Canterbury, ruled over by the Archbishop of Canterbury. And the 1963 Ecclesiastical Jurisdiction measure, which is where Norman got us up to, decreed that the courts for the provinces were to continue. So that's the Court of Arches in the yellow bit in the south, and the Chancery Court in the north. And as we've heard, the Dean and the Auditor are the judges for those respective courts, but since the 1870s, they've been the same person. There are two main types of case nowadays. We don't have this extremely wide jurisdiction that we used to have, and the two main types of case are clergy discipline appeals, known in the church jargon as CDMs, and I've given there the materials there, the statutory materials. Usefully, the Church of England website allows you to download the standard forms that you need. So if you ever find yourself assisting somebody who finds themselves in that position, you can find all those useful things on the website. The other main jurisdiction nowadays are faculty appeals. And a faculty, for those who don't know, is a permission to make a change to a church, to consecrated church or churchyard. And again, I've given on this slide the main statutory materials. Appeals, from where? Appeals always have to come from somewhere. Well, dealing with disciplinaries first, they come either from the Bishop's Disciplinary Tribunal. These are set up ad hoc as needed for the respective dioceses, and they deal with humble parish priests and other clergy. Then alternatively, the Vicar General's Court. There are two of those, one for the Southern Province, one for the Northern Province, and they deal with discipline involving bishops and archbishops. But both sets of tribunal have their appeal to the Court of Arches in the south and the Chancery Court in the north. And there are different rules here. The respondent, so that's the cleric undergoing discipline, may appeal against any penalty. So that, if you like, is an appeal against sentence. It's like that. And the respondent can also appeal on a question of law or fact. And the designated officer, who is the designated officer? Well, the designated officer is effectively the prosecutor. He or she is limited to appeal on question of law. And on the faculty side, where do the appeals come from? They come from the first instance courts, which in most places are known as the consistory courts. As Norman mentioned, in Canterbury, rather specially, it's known as the Commissary Court, presided over by somebody called the Commissary General, who sounds as though they ought to wear epaulets, but I can tell you they don't, because I was it for about 10 years, and I never wore any epaulets. And again, there are the statutory materials there. There are exceptions to those rules because, as you will recall, I said that most faculty and CDM appeals go to the provincial courts, but not all of them do. And those who are close to the slides will see that I've played around with the font here because the exceptions relate to things called appeals involving matters of doctrine, ritual, or ceremonial. So I've put some fancy print on there to remind us about that. And what this is a little family tree, if you like, showing where everything goes, from the consistory courts, who deal with both kinds of faculties. So the consistory courts have to grapple with matters of doctrine, ritual, or ceremonial, whatever they are. Those matters go up on the right-hand side of the slide there to the Court of Ecclesiastical Causes Reserved, which we've heard about already briefly this evening, and then on from there to something called a Commission of Review. And non-doctrine appeals come to the Court of Arches or the Chancery Court, and thereafter they go up to the Privy Council. And the idea behind that, as Norman briefly referred to, is that the Privy Council, being an entirely secular court, shouldn't be ruling on matters of doctrine, ritual, or ceremonial, whatever those mysterious things are. And on disciplinaries, similar sort of arrangement. You've already heard where non-doctrine appeals come from, the tribunals, Vicar General's courts. Doctrine appeals, or rather doctrine proceedings, go first of all to the Court of Ecclesiastical Causes Reserved. So for CDMs, it's a first instance court, and thereafter up to the Commission of Review. So subtly keeping all those secular judges not having the final word in the Privy Council on those doctrinal matters, although some secular, very senior judges sit in the Court of Ecclesiastical Causes Reserved. So what is a matter of doctrine, ritual, or ceremonial? There are a few slides on this. Really, the lines are blurred. For example, Mark Hill, who's sitting over there, who's written a leading practitioner's textbook, and this won't be the first advert, the last advert for that. Mark looks at this and really says, well, it's all rather blurred. He refers to writings on this, learned article, and a case called Bland against the Archdeacon of Cheltenham, where a priest had refused to baptize a baby, basically because the priest felt on doctrinal grounds that more was required than just a couple turn up for the first time that he's ever seen them with baby in arms and say, will you baptize? So there was an interesting discussion about, well, was that a matter of doctrine or was that really a matter of good order? And the Court of Arches decided that it was a matter of good order, and so it was a disciplinary matter rather than a doctrinal matter. And partly perhaps because of that case, the Court of Ecclesiastical Causes Reserved has never tried a disciplinary case, not yet. There are, however, rumblings and whisperings going on in certain quarters about the vexed issue of prayers of love and faith, which some of you may have read about in the newspapers. Potentially, the CECR may have something to do, Sir Stephen. Second slide on these matters. In the faculty jurisdiction, you might say, well, I thought faculty was all about buildings. Isn't that really just a bit like a sort of churchy planning permission arrangement? Well, not quite. Arguably, everything to do with church buildings is a matter of doctrine, ritual, or ceremonial. And a very learned architect and academic called Kiekhefer wrote a fascinating book called Theology in Stone, Church Architecture from Byzantium to Berkeley. And if you just gaze around this church with the eye of a little bit of knowledge in church architecture, you'll know that in just about everything that we see in this church, it is actually possible to discern theological statements and significance and matters pertaining to ritual or ceremonial. And there's rather a nice, much more approachable book called How to Read a Church, a Pocket Guide, which I've quoted from there. Churches and cathedrals are packed with meaning. Outside, the spire points heavenwards, while carvings around the entrance announce the holiness of the space inside. All around, numbers, colours, the animals and plants in the stonework and the scenes in the stained glass point to aspects of Christian teachings about gods. In a number of senses and to different degrees, churches were built to be read. So, arguably, everything is a matter of doctrine, ritual or ceremonial. There's a little example here, and those who are close enough will see, because we're going to be thinking very briefly about something called chancel screens. And this is a photograph of a chancel screen, and it's ornately decorated with flowers, because I couldn't find one that was free of copyright. So you've got a Bushell family wedding photograph here from our parish church. And the chancel screen is less ornate than the ones I'm going to be referring to in the case law, but the function is the same. And you can see, and if you look at this closely online later, the screen, it separates off the chancel in a traditionally laid out church. We don't have a chancel here. It half separates it, so you sort of see through, but you don't quite see through unimpeded. And what this one does is, if I knew how to do a pointer with this, but I don't, so I'll do it with my hands, it's channeling your view through to this lovely stained glass window, which has the crucifixion in the middle. So the central arch of the chancel screen is training the eye onto that. Underneath is the altar, where we celebrate the sacrifice of the crucifixion. And just above, there are some wall paintings with the lamb there, very much like the Middle Temple lamb, representing the sacrificed Christ, with some lovely angels swinging censers either side, and there are angels lower down too. So you can see it's absolutely, arguably, packed with theology, is that. So, did cases about chancel screens get sent off to the Court of Ecclesiastical Causes Reserved? No, they didn't. They stayed in the Court of Arches because jurisdictionally something rather more is required than the sort of thing I've just been talking about. But if you are new to the Court of Arches and ecclesiastical law, don't assume that you can go there and not be expected to engage with Christian concepts and practice. And these cases on chancel arches are very good examples. There's a case called Duffield and another one called Penshurst. And particularly in Duffield, the people were wanting to remove the chancel arch, very, very beautiful Victorian, one of high heritage significance. They wanted to remove it because they wanted to do more open, modern styles of worship. They didn't like this idea of the part of the church being half fenced off from people. They wanted to express the openness of God's love. So there was a lot of discussion about that, and the law relating to Christian doctrine, and there is some in the Church of England, and the law relating to what clergy are required to believe or not. That was all considered at length in the Court of Arches, albeit obiter. But as I say, don't assume that you can go there and stick to what you might think of as black letter law. Another good example is a case called Blagden Cemetery, very, very important case on exhumations. Exhumations are one of the main types of faculty petition that we have to deal with in the jurisdiction. And in Blagden, there was very lengthy and learned evidence from a bishop on the theology of the permanence of Christian burial. But a case going in the opposite direction. In a case called Spitalfields, where I had the misfortune of finding myself appearing in the Court of Arches before my predecessor, Charles George, who is sitting over there, on, it might be said, a rather tricky case. I dreamt up some, I thought it was frightfully clever point to do with the difference between an interment and a re-interment to get round a late intervening point which had cropped up. But Charles was very polite about it, but quietly dismissive, and said, well, if we were really going to go into all of that, we'd have to send this off to the Court of Ecclesiastical Causes Reserved, and you don't want that, do you? So there we go. The CECR has sat only twice in a case called Torrington, dealing with a votive candle stand. I think it's quite surprising, actually, that that one ended up there. It was not a terribly significant case, but much more significantly, the case of the round altar, but designed by Henry Moore for St Stephen's, Walbrook, which I'm sure many of you will know. You can't go and look at it at the moment because the church is being refurbished, so I couldn't take my own photo, but I've got one here I'm allowed to use. Lots of theological discussion about whether it was possible to have a round altar, whether it was possible to have a stone altar rather than a wooden table, and hours of exciting theological and ritual fun there. So that one went off to the CECR. Right, swiftly. Permission to appeal is needed for both disciplinary and faculty cases. Application is made to the dean sitting alone now in both jurisdictions, and the test is the same as the civil test under the CPR for going to the Court of Appeal. Real prospect of success or some other compelling reason why the appeal should be heard. Very importantly, going back to what I've just been talking about with doctrine, etc., a certificate has to be given by the lower court to certify that it's not a matter of doctrine, etc. And so the litigants must make sure that they get that. The renewal application is made to the dean alone and determined on the papers. Real prospect of success, very, very swiftly there. The test is not just an arguable error of law, so it's not like the judicial review threshold. It is real prospect of success, and that needs to be remembered. On penalty cases, it's whether or not it's excessive. And generally speaking, and I've cited lots of cases there for the students and the advocates, the court is not going to get into discussing the veracity of witnesses whom it's not heard. So quite influenced these days, I think it's fair to say, by the secular appellate approaches and jurisdiction. Then some other compelling reason. A recent disciplinaries one was the interesting question of whether or not certain things were material averments in a disciplinary. And on faculty, a fairly recent one there, looking at really, is the case going to be a useful opportunity to settle some things, back to that settling again. And the court there took into account the fact that probably there would be litigants in person and therefore perhaps less useful. Oral evidence, generally not. Permission for admission of fresh evidence on appeal, both for disciplinaries or for faculty, basically the same as Ladden Marshall in the secular jurisdiction. Addition of parties and interveners. I mentioned one in Spitalfields. Again, it's really quite similar to the approach taken by the secular courts. A recent case, actually it was my first case sitting as dean, about an Irish language gravestone, and we allowed interveners, including the Conradh na Gaeilge, the Irish Language Society, who gave some very useful evidence on that interesting case. Powers on appeal for disciplinary, they're all set out there. They're fairly broad-ranging powers that the court has to impose different penalties or to send things back for redetermination. A particular factor in these disciplinaries is that the law does recognise the role of the bishop in the disciplining of clergy, which is a very, very ancient principle, going back at least to the Council of Nicaea. The rules still recognise that, although, interestingly, in the draft clergy conduct measure, which will be coming up before Dame Elizabeth's committee in Parliament, I think, before long, there is a subtle change there, because there is now a statutory purpose to the system, being to maintain the collective good standing of clergy and hold to account those clergy who fall below the standards expected of them, and then also the role of bishops and archbishops. So that's a subtle change that the committee, I'm sure, will consider very carefully. Right, I'm going to have to zoom on now. Faculty appeals and mode of determination generally. Normally, it's done by live hearing, but there is provision for appeals in faculties to be determined on the papers, and we've done that once in the case of St Michael and All Angels, Berwick, with the consent of the parties, but as always, the overriding objective applies, and we were looking there to save money, which we did. On appeal for faculties, court may remit to the consistory court, as we did in that Berwick case, or may redetermine the petition itself, as happened in the chancel screen cases. The general approach in faculty appeals is, I suppose, hands-off-ish, looking at reasoning and rationality. It's again similar to the approach of the secular courts, and I think it's fair to say is probably influenced by the fact that the last two deans have also been public lawyers and planning specialists. Precedent, does it apply to ecclesiastical courts? This is a very interesting question indeed. Norman touched on it extremely briefly. All these common lawyers who've been practicing in the Court of Arches and the other courts for quite a long time now, I think have rather tended to assume that it does. But there's a tantalising nugget in a 2019 response by my predecessor, Charles George, responding to a lecture given by Professor Norman Doe, in which he says that careful readers of the then new 2018 amendment will have noticed the absence of any reference to precedent, binding or otherwise, and that oversight was deliberate. So don't assume that the question of precedent is, in Norman's words, entirely settled. But the rulings of the two provincial courts do now have equal status. That's what the 2018 amendment achieved. Very practical matters now. Legal aid, yes, you can get legal aid for CDMs, and the materials are there. Costs, there is a costs jurisdiction. It does have to be borne in mind. I think it's probably rather more discretionary than in the civil courts, but don't forget about that in either jurisdiction. Reporting, that's becoming quite an issue, and the general principles really balance in disciplinaries Article 8 rights, respect for family and private life, but looking at it in the context of the overall interests of justice. But there is power, and it is sometimes used to redact and otherwise to protect the identity, particularly of children. Now, very briefly, all those questions you didn't quite like to ask. Where does the court sit? Where do I go? I've got this brief in the Court of Arches. I don't know where to go. Well, you still go, usually, to St Mary Le Bow, but for some faculty appeals you may go to the church in question. That happened in Duffield with the chancel screen. Housekeeping. Hearings start and end with prayers. You don't have to be a practicing Christian or an Anglican to appear in the court, but we do start and finish with prayers. Mode of address, this sort of Your Holiness thing, which went on in the 1500s that Norman was talking about, has now been dropped. When writing it all down, it's right worshipful for the Dean and worshipful for the Chancellors who sit with the Dean. 2 Chancellors sit with the Dean in faculty cases, but in court, Madam or Sir is what we go for nowadays. Usually no robes, but the court will direct. And a word to the wary, the acoustics in St Mary Le Bow are very boomy, more boomy than here. So, and the Dean is rather deaf, so remember that. We do technology these days. With regard to the overriding objective. In my first case, Exhall, there was a lot of interest in this, and we were still in the COVID era. And people, all sorts of people in Ireland were interested, Irish journalists and people around the world. So I thought, right, well, we need a direction for live streaming. But that was not terribly simple. And I wrote a great long directions hearing, trying to work out how I could do this, and hoping against hope that the Attorney General wasn't going to turn up on the first morning and put a stop to it all, because we did live stream, and a lot of people watched us online. But just to make assurance double sure, we've now had something put in the miscellaneous provisions measure with an express power for all ecclesiastical courts to make use of that and not to fall into traps of it being a contempt of court. There we are, a lovely picture which I was given by the administrator at St Mary Le Bow, and in your own time you can read all the theology in that. There's absolutely tons of it in that very beautiful layout. And then a pointer, a survival pack of where you can find things easily. And the Middle Temple Library has all the inn's collections of ecclesiastical law helpfully gathered together in the same place, which is extremely useful. And I've included there Mark Hill's book, which is more approachable than some of the others. And there we are. Those are the arches in the crypt at St Mary Le Bow, where they also have a very nice cafe called St Mary Below. Thank you very much.
Well, weren't those 2 fascinating lectures? It's my privilege now to propose a vote of thanks as we sit here looking underneath the arches. You've heard briefly what my role is, which is as a member of the Court of Ecclesiastical Causes Reserved, which Morag mentioned, and also President of Clergy Discipline Tribunals. Being a member of the Court of Ecclesiastical Causes Reserved is not an onerous task. It has sat twice in its 60 years of life, a brief flurry of activity in the 1980s, and nothing in the last 40 years, although I'm a bit alarmed to hear that there may actually be some cases thinking about coming our way. Being President of Clergy Discipline Tribunals, on the other hand, one can't say that that's a case which doesn't have anything to do, unfortunately, but let's not go there. let me just tell you something about the last case that the Court of Ecclesiastical Causes Reserved had to do. It was, as you've heard, about the Henry Moore altar, which was going to be in the centre of St Stephen, Walbrook. And the doctrinal issue that arose was, could you have an altar in a Church of England church? Because an altar, it was said, I think the Chancellor, hearing it at first instance, did say, an altar is something on which you make sacrifices. And that's not the doctrine of the Eucharist in the Anglican Church. Rather, what we have in the Church of England is a table around which we have a meal. And so, a vast amount of money had been spent, I expect, to commission this work from Henry Moore, and the Chancellor was saying, it's got to go. So they appealed to the Court of Ecclesiastical Causes Reserved, which is a court whose membership consists of 3 bishops and 2 lawyers. And the bishops and the lawyers worked out a solution to this. There was a lot of debate about something called the concept of tableness, but they decided, which sort of probably tells you all you need to know, really, I expect. But they decided that something could be a table, even if it also looks as if it might be an altar, and that a table didn't have to have legs, and that a table was merely, borrowing from Dr. Johnson, a flat surface on which you could put things. So it survived, and it's there, and when the church is open again you can go and see it. But since then, no activity. Isn't it marvellous to learn about the various titles in the ecclesiastical courts? To have a Dean of the Arches. I never knew really what the Dean of the Arches did, but now I have a better idea. To have a Commissary General, which sounds almost Stalinist to me, but I'm sure it's not. It's almost a shame that we don't have a vicegerent in spirituals anymore. Although, thinking what happened to the last one, perhaps that's not a role that anybody would want to have. But as we've heard, the ecclesiastical courts go back, the Court of Arches goes back 750 years, which is considerably longer than the High Court or the Court of Appeal, which in their present form, of course, are Victorian creations, and that the work which has been going on all that time continues today. It was intriguing, to me at any rate, to hear of the rules against keeping concubines, which does make you wonder what was going on. There's no need for a rule to stop something which nobody is doing. There's no need, for example, to have a rule against keeping elephants, because nobody would think of doing it. But obviously concubines were quite a problem at that stage. So that would have been one for the clergy discipline measure of its time as well, I expect. It's good to think that churches are packed with theology, and that there is theology in everything you see, and that churches are built to be read. Another way of looking at it is that everything you see in a church was once the object of a faculty application. Everything you see is potentially a piece of litigation, a thought with which to gladden the hearts of a legal audience. And I know that I have learned a lot from these lectures and been stimulated by them. It's whetted my appetite to find out more, and I'm sure that much the same will apply to you. In the words of F.E. Smith, I feel both considerably wiser and also better informed. So will you please join me in thanking our 2 wonderful speakers for the talk that they've given.
Thank you so much to everybody. I was thinking of give out some parish notices, but I don't quite mean that. Making some reference to the programs of the 2 societies, the Middle Temple History Society and the Inner Temple History Society. Please look out on the Middle Temple website for the events that are coming up this year. Amongst those will be the joint one with the Inner Temple History Society and the History Society of the Four Inns. Lord Sumption will be speaking in that Selden lecture, and his talks are never without interest. So far as the Inner Temple History Society is concerned, we haven't quite finished with religion yet. The next talk on the 8th of May will be by the brilliant legal historian, Professor Michael Loban of Cambridge, who will be talking about a little-known series of litigation in the 19th century, where Dr. Bernardo was brought before the courts and sued in order to retrieve certain Catholic children by their mothers, who he thought were better off being brought up properly in the Church of England and not under the rules of the Catholic Church. Their mothers thought otherwise. It was a very interesting series of litigation. So that's on the 8th of May, and I would invite you to come along. It's open to all, and Professor Loban is a particularly good speaker. It will be a very interesting topic to many. Thank you all very much. The food and drink are at the end of the church. Thank you.